Meron. Meron, I bet to mention the unlisted item, anticipatory as well.
Today will
Yes,
not
sir.
be possible. Monday. What is the urgency?
Just 2 minutes.
What is the
Pre-arrest-
urgency?
it's Pre-arrest bail. Bail application.
Can you get it immediately?
Ah,
Can you get it immediately?
yes.
List निकाल देने बोलो.
Much good.
Where is Mr. Nawab?
He's not present.
Weather or something else? Weather. I have talked. We can have it on 19th. We've got it. No problem. And you have your that records ready.
Otherwise, I'm trying to get the.
We've got it.
Otherwise, no, sir,
Mr. Das, one thing. Now that there is a specific direction from the division bench, the last point that how to the issue that whether a power of sorry, a power of attorney holder on his own can maintain this position. I would have understood the other way around. Petitioners are there, but he is only the signing authority. And I don't find a statement here that he is also one of the persons who is affected by the. So kindly address me on that issue. I've gone through yesterday, not been able to get my hand on.
We'll see, we'll address it.
Because if you look into the Power of Attorneys Act also, Act to the Power of Attorneys.
Section 2.
Yes.
And if you go through the decisions also, it says that you can institute a proceedings. There is no proceeding, but it should be instituted always in the name of the donee. Donee, not the holder. So kindly, when they filed that writ petition, you were not there. That issue may have not been examined.
I was not there.
You were not there. That's why I said that it was not examined.
I tried to find out
Huh.
when I found this issue. That's why I addressed first.
You told me it first.
I addressed first because that's a major.
That was something which was.
That purpose, because your lordship has to look into this.
No, we can find out ways and means.
By finding some additional.
You
That's
can.
I thought.
You will have to
Because
maybe
the-
subject to correction.
This doesn't go to the owner. Maybe I also thought,
Oh.
maybe it doesn't go, but it should be a proper way.
From
So
format.
that your lordship finds it easier.
No.
Whichever this way or
See,
that
for
way.
me, by exercising 226 power, maybe I can ignore many things. I can ignore many things because your prayer is that the payment should go to the parties.
Yes,
Yesterday, there was a matter here
yes.
wherein the mother-in-law had instituted a proceeding claiming compensation in favor of the for death of her daughter-in-law. Initially, I was totally against it. How can a mother-in-law, she is not even a legal head, how can she maintain a proceeding? Then when I saw the prayer, I saw that that payment is sought for in the name of the minor. Then I requested her that kindly amend the cost title. Give me an amended cost title so that we have a matter in a proper perspective. But here that may not work because there will be no statement.
So what can be done for the, because we have to legally
Say this.
Not because of the proceeding.
No.
Legally, because if this is the first point first point has to be addressed and your lordship has to decide the first. point.
Yes,
Then the question of the second point.
because why I'm saying, so if this decision goes against you, that is the end of the matter.
That's what I'm saying.
So,
Tomorrow, today, lordship, we'll not go into the other aspects of the matter.
because
We'll see the
this
first aspect
proceeding
of the
is not
matter.
in a proper format
First-
before.
first aspect of the matter.
Because I am bound to do that
Now-
because there is a direction from
No,
the
your
division.
lordship can also, for the end of justice, suppose for a moment we don't rectify. Your lordship may give a direction for rectification of this proceeding.
No, that,
If at all. if
that
at
may
all.
not be possible. Why I am saying so? I would have resorted to the same procedure which I had resorted to that lady's case. But in your matter, that may not be possible because there will be no pleading.
No, no.
The
what I'm
whole
saying-
proceeding would be without,
What I'm saying is necessary, we can bring it by an official ability also.
you,
If necessary. No, I don't know, my lord, I have to go and. sit-
you examine that.
Yeah, I have to-
This is not a conclusion I have reached.
No, no, no,
This is
that's-
something which I have found,
No, yes, right.
which I thought that I must share with you.
Two, three things are there which
Because
I.
if
No,
this,
then this matter came to play. First, when I saw the division bench order, then I see then I started seeing the pleading of the Union of India.
it's not there.
Pleading of the state. bank,
That I told you
of the
yesterday
state.
also.
Not there.
It's not there.
So normally, in between,
The Union of India's initial affidavit is also very sketchy.
now,
The only additional affidavit, they have brought on something on record.
now today, let us see that we examine the judgment of the Supreme Court, all the judgment of the Supreme Court. Finds that you cannot raise this point in between. Once, we cannot raise this in between. Then what is the effect of the order?
See,
Whether you
no,
want it.
no, I would have understood a situation wherein you were not there before the division bench. Now you were there, in your presence, this order
Where?
has, before the division,
No, I was-
not you,
No.
means your client.
Sorry,
Your client was there. So it was an order passed by the division bench after hearing your client. Now, I would have understood a situation in that way if you had filed a review before the
Right.
division bench and then got that matter reviewed to that extent, at least the last line. If it was reviewed, then everything is open for me. But now that order standing and that too by and between the parties, forget the Supreme Court decisions. I would be bound by that order. I would have
No,
to,
that's true, my lord. Your lordship cannot overreach
I
the
can't.
order of the division bench.
because
that
that's an
may-
order by which the matter was remanded to
Yes,
this court.
of course. Of course.
So kindly,
No, I know one teacher's case, that some division and some act, was people challenge, people division, bench. I don't know this also. Then I have seen that due to the affidavit which was filed, wrongly, it was supporting our case, but by mistake, that said that for the inspector of school, the BA was compulsory. Your lordship remember, then it came before Lalit Singhal judge. I know Lalit Singhal marked that point. I was engaged. Then I said, no, you can't, you have to review that order.
review that order.
So I went and reviewed that order and showed, and ultimately it was reviewed. That may be a situation, I don't know. But let me
Because
examine.
they may also take up a plea. They may also take up a plea that this is a
Okay.
point.
Sorry, all are competent, all the lawyers are competent, who is handling. But this one, I would have raised that first point that whether the learned division can enter into respect of the matter in between where you don't take the first instance.
I have thought on that lines also yesterday. Then they may come up with a plea that this is a law point.
No, that's a.
We can take it up at any point of time. This goes to the root of the matter. So maybe then I will have to answer that issue. But before we do so, kindly,
No, I will accept.
kindly examine the issue and if possible, apprise me that tentative view that I have expressed, that whether a donee, without the donee or the donor, if I may use it, the donee can get the
I will-
proceeding instead
no, I-
without the,
I will look into.
you
all
have
this.
appeared in a lot of company matters,
No, I will.
tender matters,
Yes.
but it's all done by power of attorney
Yes.
holders, but the name is always of the, so
Yes.
kindly, right. Mr. Fukan is
and
there,
one-
Mr. Fukan is there, give him that homework.
Fukan is only problem,
Huh.
19 is not there. So-
Yeah, that's okay. That's no
No, we'll have it if
No, no,
required
no,
on,
no,
no, no,
19 was
no.
tentative.
No.
Oh, I am there from next week onwards. There is no problem. You give me a date because Mr. Das would require
But let-
your assistance.
But because he, I think, will be out of session. But he said it's
Oh,
okay.
then we can't help it.
How?
We can't help it.
Let it be on 19. Let it be on 19.
We can have it. When are you going, Stefan?
I will be out of station for 15th.
15th.
After that is a vacation, so I don't think your lordship should do. 19th is fine.
Not just
Yeah.
Before that,
There are
it
a lot
was
of-
possible.
Yeah, we'll have it on, 10th or 11th. No problem.
10th is here, some matters are fixed.
11th. Then we'll have it on 13th.
13th
Or
is
even-
not. Well, even when, even 6th.
6th, no problem.
Six.
6th,
6th.
6th,
It
we'll
will
have it
be
on.
fresh. Only
Will be
one
fresh
thing-
also.
Yes, only one thing, your lordships kept it 19, but 6th, I want some assistance from him also.
Oh, that's why I said
So subject to condition of my learned friends who are here.
6th, no problem.
No, no.
But you will have to take the trouble of coming online. If
Yes.
not otherwise, they'll give you a link. They'll give you a link. Link कर दीजिएगा. So
Your lordship is why online? Because we come here, we also come here, then they should be with us.
I'll not trouble them. They are very busy here. We will not trouble them. Every other matter I find them.
Come to.
We can take Mr. Nawam also. We can take him to the, you can then take him to that place for golf. Anyway,
And if necessary, we'll see it. I'll look into all this aspect of the matter.
kindly.
Yes.
Heard Mr. D.K. Das, D. Das, learned senior counsel assisted by Mr. R. Pukan, appearing for the petitioners in the matter. Also heard Mr. D. Dole, learned counsel representing the Union of India authorities, and Mr.
The Kandu.
Kando for the
Respondent
Land
members.
Management Department, and Mr. He is Nabam,
RH Nabam.
R.H. Nabam, learned additional advocate general, appearing for the state respondents. 8 and 9, assisted by Madam K. Wangpu, appearing for the respondents number 8 and 9. The arguments of these arguments of Mr. D. Das, learned senior counsel, appearing for the petition made inconclusive. Full stop. As agreed to by the parties, list this matter again on 6/6/2024 as a parted item.
He does not get the benefit of doing. He does not get the benefit of doing.
Let us get out of that two
Because
spaces.
there is judgment, which my learned friend was saying. There is a judgment on the Supreme Court clearly says about this compensation, what is the role of a power of attorney? How it is, that's will, I think, to some
You can
extent.
give me that judgment a day before so that I can also, you can give it to him if you have it.
And 2, 3 things are there which they really help me also. Where
That's why I
whether-
wanted them
Yes.
with you.
And whether sanction is required or not, that's certain.
That is another
that's a-
gray area.
Now we know, it's a fine, settled. Well, I didn't say anything. I didn't want to disclose my card, I will disclose at that time, whether that was required or not.
That gap.
That is not required, it is required in view of other sections,
Regular acquisition.
regular acquisition. I'll tell you,
17, it's not required.
not required. Which is parameter.
So you got to show me that there was a in principle approval.
Yes.
In terms of that in principle approval, now that matter is very clear that it was done by the Defence Estate Officer. So Defence Estate Officer having done a joint survey, and if you go through the papers, you will find that the joint survey report was forwarded not by the state. It was forwarded to the state by the district, the Defence Estate.
Decision officer to the Raksha Mantri.
Then for their signatures,
Yes.
after he had signed it. So that shows the application of mind and
Application,
their
yes.
intention.
Whether.
So
it-
now the gap is 4 months. Why did they wait for that 4 months?
And in 2018, you decided, otherwise, what would be the effect of the letter from page 67, where you have written?
And their
Otherwise,
letter,
you could have said, even on 2067 letter from their side. is
another
not-
aspect which you also may have to address is, they had given a letter to the 2018-19 to the government, saying that now we have received the approval of the Union of India government, that we don't want to proceed with this. Now, the question would be, that is one aspect, whether that was also percolated to you, whether you knew about it. Whether you knew about it,
Knew about it, but it was never intimated because it's subsequent to the notification.
because then this proceedings, we'll just get the boxes ticked so that we can proceed further.
These are all subsequent, these information, all this 2018 is subsequent to the notification. Your lordship will
These
take
things
it.
are also very new to me, so I'm also
No, I
trying to
can't
learn.
say so.
I'm trying to
subsequent to
learn.
the notification, but very impact of 40, I have seen all the judgment is different.
No, you had placed that judgment yesterday wherein you have read the parameteria provision under 17. So,
I don't
fine.
know, my lord, if at the very first instance for interim order 80, because we are in the stage of conclusion of the case. But the intention of, I have gone through it. What was the intention of the legislature of 43? 43 is that they have been displaced and 80% immediately you pay to them.
But then my question to you would be, why did you not exercise that right at that point of
No,
time,
we-
making a
we-
claim?
No, we could, that's why I'm saying my.
Because say 41 cannot be read in isolation. It has to be read with 43.
No, that's why I'm saying, when this matter was moved, when you see, I was not there, I came
Understood.
later on.
Understood.
Then I explained, with the help of my management and I said, the 43 is there, my Fukan said, see, this is 43 is there.
Because
So
that was a
80%
direction immediately to
80% should have been paid, because we have been displaced. That is what is parametry of 73. Old act, 17,141, 73 is parameter of 43. 43 is a parameter, that's what the Supreme Court decides. That no, there is no reversion, there is no going back. And what it says further, some irregularity, illegality has been done, either by the union or then the landowners would not be suffered. That's clearly it's a myth.
You just give a list of judgments if you have.
We'll give
There
there
also.
before.
There,
one
here,
day.
wherever it's possible, before, if you can give it the week before, so I can, the weekend, I can just go through that.
Yes. I am deeply aware.
Thank you.
Thank you.
ये आप नोट रखना एक बार, इसको नोट रखना। Causeless यहाँ से बोलना पड़ेगा, यहाँ से बनेगा, वहाँ देगा। ठीक, 2 बजे का करीब लगा दीजिए। हाँ, 2 बजे लगा दीजिएगा उसको। This is matter at on 6/6/2024 at 2 p.m. Yes.
Madam, the FID page 14. There are so many backgrounds.
You went up to the Supreme Court,
My lord.
huh? And the presently you are under protection of the order that is still continuing. There was a Supreme Court order here, page
The case, my lord. 56.
So today, no protection is required because you are already protected. We will have the case diary, we will fix it on a date convenient and then we will decide. Because the Supreme Court passed this order, maybe limiting it to 1 month, because our submission was made that you had already a proceeding before the Sessions Court.
My lord.
Right.
By state.
Not on that. That's why this court said, the Supreme Court said that you examine that on its merits.
My lord.
But you have now contended that there was no such proceeding.
My lord.
Case diary will reveal all those things.
Right.
Then we will proceed further. The heard Mr. K. Tama, learned counsel for the petitioner, also Mr. So-and-so, learned additional public prosecutor appearing for the state respondent. So the present application is instituted by the applicant herein, praying for regular bail in connection with Nirjuli PS case number 21/2024, registered under section 306 of the 306 IPC, which was so instituted basing on an FIR lodged in the matter on 21/3/2024 by one Techi Peki Tara. Also, issue notice returnable on issue notice, full stop. Call for the case diary in connection with Nirjuli PS case number 21/24, full stop. Fix when
5, 6. 6. It's nearby.
nearby. You are here on 6. 6 on 6/6/2024 for production of the case diary. Okay. What is the stage of the proceedings now?
Your Lordship, 164 has been done and procedure has been.
What is the police station case number?
Basar PS, FIR number 15/24.
No, the Basar police case number, police station case number.
GR number 19/23.
No, not GR. It's still there is the CD only. What is the case number? FIR case number. Basar PS case number is how much?
I haven't looked at the FIR number.
Hmm?
FIR number.
GR number 1924.
GR is with the court. What is the police connected police station case number?
It's a GR, FIR and GR number only. We don't have other things.
Charge sheet has not been filed, so
Yeah.
there is no point in calling records from the court. Right?
Yes.
क्या लिखे हैं मैडम? Of Basar of the case registered in pursuance to lodging of the FIR number 15/2024 under section 66E of the IT Act 2000. Right? Yes, madam.
Your Lordship, this is a joint criminal petition filed under 482, praying for the quashing of the proceeding of ITA WPS 32 of 2019. Here the section is 376, which is non-compoundable. And this is filed, it's a joint petition. Petitioner number 1 is the accused, who's 27 years of age. Petitioner number 2 is the victim informant, who is 25 years of age. This is basically a love affair which couldn't work out due to some misunderstanding between the petitioner and the petitioner number 2. Now it is in the stage of PW1 after the CC has been conducted.
The allegation against PW1 at page 35.
Yes,
Rashid,
yes, Your Lordship.
is serious.
The-
But if the PW2 had projected this wrongly,
Yes, Your Honor.
is she not responsible to be proceeded against? Whether
We-
this compromise will absolve her from that? So I've seen the medical reports are not here.
Because
But-
this,
She has lodged this case after a long time.
yes, after 8 months.
So malicious prosecution.
That is there, but we will also have to take into account that,
No, we
At
would
that
have
point-
taken it into account if it was a case wherein. Yes, what do you say?
LCR, skin copy of LCR may be called for. Because this is an offense of 376.
That-
Judge under 376.
If the lady is saying that that is not there today, which is also again from the, if you look into the medical report, maybe that will also be, the charge sheet has been disclosed.
Yes, charge sheet.
That means she had lodged a false case against the petition number 1.
Yes.
This court cannot close its eyes to that one.
That was, actually, that point was put up during the CC also. I did
No, I've seen
argue
it.
on that
The
point.
CC also, that point was there,
Yes, Your
but
Lordship.
that was not accepted.
Taking into account the 164 statement given by the,
Because at that point of time, you were that, what do you call that?
the
Agreement had not been executed at that point of time. It executed
Yeah.
nearly a year thereafter.
last year, that is.
Last
But
year.
uh,
This charge framing is of 22.
yes,
The
They-
execution is of 23.
yes, that is there, Your Honor. It is of 23/3/2023. But the
Madam, if you now say that that was a false thing, you have wasted the
I
time
am-
of the court. You have
I am not
wasted the
saying-
time of the investigating authorities.
if Your
I would have
Lordship,
understood a affray between a husband and a wife. That is a different thing.
Your Lordship, here the thing is that the both the petitioners were very young at that point, 20 and 24. Now they are 27 and 25. And it was because of the whatever misunderstanding they had, and then the parents,
Misunderstanding would not be a situation to level an allegation of 376. They were in a consensual relationship.
yes, it was actually
It's very clear
470.
from the charge sheet.
Yes, Your Lordship.
Anyway. Heard Ms. S.V. Dharan, learned counsel for the petitioner. Also heard Mr.
G. Tata.
Petitioner, sir. Also heard Mr. Sonsol, an additional public prosecutor appearing for the state respondent. Issue notice, returnable. How long does it take for the scan copy to come?
This
is
matter is from,
It's,
Papan Bara here only,
yes, it's pending before the
Uh,
Sessions Court.
after 3 weeks,
yes,
3 weeks, or 2 weeks you can get it,
3 weeks.
3 weeks. Full stop. Registry to procure the scan copy of the proceedings of session case number session case number 25/2022
22, yes.
from the court
Okay.
of the session judge
Done
UPIA,
it.
or not UPIA, it's a capital complex UPIA,
No,
Oh, no,
it's
UPI.
Sessions Court UP.
Sessions Court.
District and Sessions.
full stop.
Your Honor,
Registry to procure the scan copies of the from the sessions court UPIA.
may I pray for the stay, although it is fixed on 29/7?
I have objection.
There is time.
Okay, it's,
Yes,
yes.
at least prosecutors may be
Sometimes-
first examine.
There is an
At least,
authority.
no,
that-
stay may be,
We are not giving any.
yes.
We only want that proven, because if it's up to me, and the prosecutor's statement is that, I think it's a fit case to direct drawing up of proceedings against it. But anyway, we will not do that.
Obligors.
They have compromised, they have compromised.
Most-
But these things should not be permitted.
Yes, Your,
It is not the intent of law.
yes, Your.
Okay,
Number 5.
May I pray, Your Lordship? Lordship, this is also the same case. The application is filed under section 482 CRPC, praying for
the conduct is an assault, and I don't think so, the conduct of the person here.
Lordship, actually here the accused was already in a state of intoxication at the night of 10 February 2017.
Intoxication, he cannot distinguish between his mother and somebody else. This court is not. going.
Now, Your
What do you
Lordship,
say?
Lordship. Lordship, moreover, Lordship, a petition also, Lordship, there, this affidavit, Lordship, as I've raised,
It's only by
Lordship.
one, not by two.
then he
You
has
take,
been, he
you
has
take,
been-
you take whatever remedial measures is to be taken here. The affidavit has to be filed by both the parties. And I'm not taking.
he has been authorized here.
Will not do. You will have to file an affidavit. Because this is a joint petition.
Yeah. In the joint
Both the
petition, he
state,
has,
both the persons have to verify. It cannot be verified by one.
but here he has clearly mentioned that he has been authorized by both the petitioners. Petitioner 2 and 3, that has been clearly mentioned.
What is your name?
B. Tapa,
B. Tapa.
yes.
B. Tapa. On the prayer of Mr. B. Tapa, list this matter again on 7/6/2024. Right. 7/6.
Obliged, Lordship.
Number 6.
Yes. Have they appeared?
This is through RCBS.
No. Last day order on 20th, I had directed them to appear or before 28/5. Have they appeared before the IO?
Yes.
Hmm?
Yes, on 24/5,
They have appeared.
Appeared,
Statement recorded.
and was recorded his statement.
None has appeared for the petitioner on call. Oh, Mr. So-and-so, learned additional PP has appeared for the state. Full stop. It is submitted by the learned additional public prosecutor that the petitioner hearing had appeared before the IO of the case for recording his statement.
But as per IO, he's not cooperating with.
Who? The
As,
IO.
as per IO,
He is not
accused is not cooperating.
Uh,
Appear though, he is not.
appeared before the IO on 24.
On 24/5.
2024. However, it is the contention. Here, however, Mr. So-and-so, learned additional public prosecutor submits that the petitioner hearing is not cooperating in the matter with the investigating officer for which the investigation has been hampered. The progress of investigation has been hampered. Also, as none has entered appearance on behalf of the petitioner in the matter today, for the ends of justice, registering to list this matter again on 7/6/2024.
Obliged.
Interim order passed earlier to continue till the next day. On the next day, make a prayer, ask the court to vacate that interim order.
Obliged.
Or better, you can file an IA to that effect.
Madam.
Yes, Mr. Pani.
But I have appeared.
Statement recorded.
Yes. So less in code number 1.
Pada. Okay, you are protected. We'll continue that interim order, we'll fix it.
It is possible for some time that. Yeah, I understand.
One more matter.
Just 1 minute, my lord.
Okay, fine. We'll have one more. Yes, Mr. Aaron.
Your Lordship, 8 and item number 9 may be considered together. It's the same accused. And they have challenged the bail cancellation. Yes. Service has been completed, Your Lordship.
Just a moment, just a moment, just a moment. Now, the IO has written a letter on 1/5/2024 that he is not an expert. So he wants somebody to assist him.
Yes, Your Lord.
Who would assist him?
We have no any instruction so far.
Have you seen this letter?
Yes, Your Lordship.
Seen that?
In fact, I produced that letter.
Then what to do?
My
Can
lord.
we-
Your Lordship,
May I, my lord? As per my humble understanding, IO is the informant of the case. And
Technicality.
the PP is represented by
Your
IO.
Lordship may proceed with this matter, Your Lordship.
You represent?
No issue, Your Lordship. Because Your Lordship, the issue is on matter of procedural law, Your Lordship. So I can appear, no issue, Your Lordship.
We'll regularize that, then we'll take it up for admissions.
Yes, Your Lordship.
Mr. Ete?
My lord, since this month I am suffering in jail since 12/9/2023, my lord. It's a cancellation of bail. It's,
You have
now,
literally now
my
two
lord,
cases,
Your Lord, interestingly, it's a 3 cases
three
there.
cases now.
And
my
out
lord.
of Your Lordship, 3 cases, the learned court below, instead of cancelling the bail violation of condition in the specific particular case, has cancelled the bail in the 3rd case, Your Lordship. And the opportunity has not been afforded to the accused. Your
Yes,
lordship.
my lord. So
It's
my
very,
lord,
your
it will be
lordship.
disposed of today, my lord.
No, no, we'll.
My lord,
We'll have to regularize that.
My lord,
Respondent
it's
number two.
9 months, my lord. I
We'll
have,
have it on Monday if required. Monday you have it. I'll just regularize this because
My
this
lord,
whole
on la-
matter, this whole issue has been pending only for this.
Yes, your lord.
Right from the date the notice was issued, thereafter all the dates, it's only pending for this.
my lord, I am a woman, my lord. I am,
We'll have it on Monday, Mr. Counsel. I'm fixing it on Monday. But I'll have to regularize this. I'll have to regularize this file. How can I proceed? This is not a bail application, this is a criminal petition. Mr. Ete, learned counsel, learned additional public prosecutor has submitted that he would now appear on behalf of the respondent number 2 also in the matter. Full stop. Accordingly, the service of notice upon the respondent number 2 is complete. Full stop. Registry to list this matter for admissions on 3-4.
Your lordship, however, I don't have the instruction to appear, your lordship. The direct instruction from the IO to appear.
I'll say at the request of the.
Yes, yes.
Yes, sir. Mr. Ete, who is present in the additional public prosecutor, who is present in the matter. Is the respondent number 2, via a communication dated 1/5/2024, which has been produced before this court by Mr. Ete, learned additional public prosecutor, has submitted that an advocate may be appointed in the case on his behalf. Full stop. Had requested the superintendent of police, Pasigar, to appoint an advocate in the matter on his behalf, to appear on his behalf. Full stop. Mr. Ete, learned additional public prosecutor, who is appearing for the state respondent in the matter on a request being made by this court to also appear on behalf of the respondent number 2, has accepted the same, and accordingly, it is noted that the respondent number 2 also in the respondent number 2 in the matter would also now be represented by Mr. Ete. Full stop. Ete, additional public prosecutor. Full stop. Stop para. Accordingly, notice on respondent number 2 is complete. Registry to list this matter again for admissions on 3/6/2024. Right?
Obliged, your lordship.
much less.
Yes, Mr. Pani. Ah. Yes, Mr. Pada, what do you say?
My lord, the CD is here, my lord.
You want him? I forget the CD. You want him?
It seems from the CD, my lord.
Huh?
It
You
seems
want
from
him?
Yes, my lord.
Okay.
Because the CD speaks.
Heard Mr. D. Panik, learned counsel for the petitioner. Also heard Mr. O. Pada, learned standing counsel, SIC bracketed VIG. Also, Mr. Panik has submitted that he, in terms of the directions passed by this court, while order dated 21/5/2024, while granting pre-arrest bail, interim pre-arrest bail to the applicant, the applicant has appeared before the IO and the statement has been recorded. Full stop. Per contra, Mr. Pada, learned O. Pada, learned standing counsel, SIC bracketed BIC submits that certain further inquiry is necessitated in the matter, and accordingly further interrogation of the applicant would be required. Full stop. Accordingly, full stop. Accordingly, list this matter again on.
Lordship, I'm appearing on behalf of the informant. There may be.
We'll hear it. We'll hear it. 12th,
My lord.
12/6/2024. Interim order passed earlier to continue till the next date of listing. Full stop. Mr. O. Pada, London Standing Counsel, SIC, shall produce an updated case diary of the matter, on the next date of listing.
My lord.
You continue. What is the, you have a bill? Absolute on
In
this.
fact, I have tried to go there, but they are not even taking my statement.
Oh, you have not recorded your
No,
statement.
Once there.
No, my lord.
Once there.
That would be very wrong.
Has he recorded even one line?
Yes, recorded, but he doesn't disclose anything. That's the
That's why we said you continue your interrogation.
My lord, that is the problem. When the person is in the
That
strength
is
of.
your problem. Your authority does not know. Who says?
Because when a person knows, my lord, that he is in a protected. My
Mr. Pada,
My lord.
there are Supreme Court judgments which says that even if it is on an interim bail, you can take him into temporary custody.
My lord.
Maybe at the night you have to release him, but you have the whole day with him.
That is.
Prosecute, interrogate. You don't know how to interrogate. Get out things. And if you fail, then come back with an application. We will do the need. But this concept that because of an interim bail, you are powerless is wrong. You're not powerless.
No, but they are more powerful than. That's the problem.
That concept you have to
That
change.
only shows the leg of the
That
police
shows
officer.
your lack of tact. You have to develop that tact.
My lord.
Those
We
days are
find
gone
Something
when you
we pass
take
into-
somebody
but
into
that
custody and
does not mean that your investigation process should get derailed.
This is the man.
And if you find that he is very hard-headed, come back with an application, we will look into it. I've told Ms. Ginny, Ms. Ginny had filed too, we have taken care of the matters. Do that. But this concept, I forgot the judgment exactly. Supreme Court has very categorically said
yes, yes.
that interim direction does not mean he cannot be asked questions. Interim direction is only that you will not put him behind the bars, but you can have his custody.
That
For
is the man.
that temporary, I think the word used is temporary custody.
Can have him put a whole day.
Whole day morning, calling at 7, leaving at
That is the
9.
my lord. But until unless he speaks out, my lord.
Yes, speak up. You have to ask him in that manner.
That reflects on their capability.
Okay, thank you.
My lord.
Meet you next time.
My lord.
Oh, unlisted, हाँ. बोला देना.
Lordship,
Oh,
informant,
you have your name?
T Topo.
T. Topo,
Yes.
Mr. T. Topo, Lanark Council, representing the informant is present.
Unlisted.
What is here? I've not seen him.
Your lordship, it's a POCSO matter, your lordship, and my plea.
Accordingly, he seeks liberty. He prays that he be permitted to withdraw the present application with liberty to refile the same after rectifying the error, the inadvertent error in filing the present proceeding. Prayer accepted. The present application stands dismissed on withdrawal, however, with liberty to refile the same.
Deeply obliged.
Thank you.